Hi, I'm Russ Bleemer from Alternatives to the High Cost of Litigation, a monthly newsletter on commercial conflict resolution issues published by the CPR Institute in New York and John Wiley & Sons. You can see it at altnewsletter.com. The May issue and our new June issue at altnewsletter.com features Phil Loree and Richard Faulkner, who once again joined me today. They talk in that about the Shine case, which is in front of the Supreme Court on a petition for certiorari again. And we expect there could be a decision after this Thursday's conference next Monday. But here today, we're going to talk about OTO versus Co., which was declined by the Supreme Court this past Monday, June 8th. It was a California case on unconscionability. The court decided not to hear it, even though there were a lot of similarities with AT&T Mobility versus Concepcion and other cases where the court has permitted arbitration to continue in the face of waivers and class action waivers and all. So, OTO, what happens next with unconscionability in the Federal Arbitration Act, gentlemen?
Well, Russ, looking at OTO, it seems to me that the denial may well have been because the Supreme Court saw the case as being extremely fact-bound. Now, we have to remember that OTO wasn't a case like Discover Bank, where you had a special Discover Bank rule that basically said all class waivers were void and that sort of thing. What you had was a very specific situation where a person who I believe was a Chinese immigrant who worked at a Toyota shop, and he was given an arbitration agreement and an employment agreement, and the arbitration agreement was in 7-point type, and it was apparently worded in a very prolix fashion, and he was told to sign it immediately. He wasn't given a copy, and it just, a bunch of facts like that, and you just got the sense that, well, that's a very high degree of procedural unconscionability. So under California law, and it's probably true, I think it's true in New York law as well, but true in a lot of other states, is that if you have a high degree of procedural unconscionability, then the substantive unconscionability standard is a lot less demanding. And in this, so when the California court got to the substantive unconscionability part, they determined that this administrative procedure, this Berman rule, that would apply in the absence of the arbitration agreement was far fairer, and that the arbitration agreement was, had protections built into it that were not streamlined. So it was kind of ironic that the tables were turned. But the California court said that their opinion didn't necessarily mean that that same arbitration agreement would not be enforceable under different circumstances. In other words, if there wasn't so much procedural unconscionability, maybe the arbitration agreement would have been okay, even though it was more, it imposed more litigation-like procedures and the like to this wage claim that was at issue.
Yeah, we have Rick. It was funny. It was two competing streamlined procedures: the Berman procedure for dealing with wage claims in California versus arbitration. And the California courts view arbitration lost. We were saying before we started recording, we've seen some of this elsewhere. Looking at Shine coming up next week, is there enough procedure having the default to arbitration buried in the delegation clause that isn't in the contract but in the rules? We had referenced Adelise in New Jersey, where the same type of idea of contract provision. Rick, what about the future of these consumer claims in arbitration?
I think that the court declining to grant cert on OTO has more import than people are thinking, because it is not uncommon, particularly in Texas, for people to have a first language other than English That was certainly true in South Louisiana when I was growing up, only it was French instead of Spanish. Now here you see many, many documents in Spanish and used routinely to try to get employees, oftentimes low-level employees, to agree arbitration. But the peculiar facts of OTO track what routinely happens in many businesses, where an employee is presented with an agreement to arbitrate. It's given to them. It is expected to be signed, returned immediately, and whether it recites that they had an opportunity to consult counsel or not, they never do, because they don't think it's a real agreement, a real opportunity to have the agreement reviewed by counsel. And when the HR person, or in the OTO case, the porter, is standing there waiting for the documents back, how much review can you have? Plus, in OTO, you had just abominably small fine print, a turgid, impenetrable arbitration agreement that even our audience would have trouble understanding on the first reading, if we could read it at all, because the print was so small. And how does the average layperson or consumer or employee in similar circumstances understand and know what they're agreeing to? And I think the fact that OTO was allowed to stand without certiorari being granted holds a lot of potential import for additional challenges to arbitration. And at the opposite end of the country, you have that Adeleze case out of New Jersey, where the court, like the California Supreme Court, the New Jersey Supreme
We lost him. Adeleze, oh, you're back? Okay. I was gonna fill in. You dropped off for a minute. Adeleze the court declined cert on that as well. And I can't recall how far that agreement went, but we can say for OTO that the California Supreme Court did say you can certainly arbitrate a case where you have a Berman situation, where there's a wage an hour, a claim, as long as you could go forward with Berman and as long as the protections were there. That just wasn't in this case for all of the reasons you're discussing.
And in Adeleze, the New Jersey Supreme Court recited almost chapter and verse how much they love arbitration, but then went on to say it's requisite to a waiver of a legal right that it be clear, unequivocal, and a decisive act of the party to waive their right to trial. And it's not just so that it would be in the arbitration context. It's not merely in the arbitration context. That is applicable to all contracts in New Jersey. So you have two state Supreme Courts reciting how much they love arbitration, and at the same time undercutting it so that it opens all sorts of doors for challenges to, was there an agreement to arbitrate? Was the agreement sufficiently clear to put a consumer on notice? And the New Jersey Supreme Court has been expanding Adeleze well beyond consumer. So it's really interesting as to see how this is going to turn out. And if by any chance the Supreme Court grants Shine 2, we could have a whole new area and era of arbitration challenges that could very well focus on consent, because New Jersey was focused on consent. Justice Kagan hit consent repeatedly in some of her language recently. And if you look at that, who knowingly and intentionally consents to the delegation of arbitrability to an arbitrator, other than maybe the viewers of this particular program, because we're all arbitration sophisticates. And remember, this all comes out of international arbitration, where we represented the most sophisticated of parties who knew and intended to avoid courts of any nation, because none of the parties trusted the courts of any other nation. And under those circumstances, that was about as clear, sophisticated, knowing a choice as is possible, as opposed to, oh, well, in the famous 3 words, you have Rule 7, and in Rule 7, you give arbitrability to the arbitrator who is self-interested. It's a really interesting conundrum.
And with that, Rick has tied in all of our recent work. I'll give Phil the last word, but before I do that, I want to note that for this week's case that the Supreme Court has dealt with on Otto versus Co. My colleague Loree Co. has written an article on it. If you're seeing this on YouTube, we'll link it beneath. We're going to embed this on the page, on the blog. It's the CPR Speaks blog. You'll also see a lot of preparatory stuff regarding the Schein case, which again is on the court's table for Thursday. That would be Thursday, June 11th. And also the material from GE Energy, which the court decided. It seems ancient history in the lockdown days, but it was really just last week that GE Energy came out and involved some of the international issues that Rick was just talking about. Phil, you have any, and of course, Phil's article and Rick's article on Schein, a two-parter, available at altnewsletter.com in the May and June issues. Phil, do you have some last thoughts on Otto?
Yes, I do. On Otto, the elephant in the room for me, so to speak, is getting the issue before the Supreme Court as to whether this California Berman procedure, can be found to trump an otherwise legitimately negotiated arbitration agreement, where the arbitration agreement perhaps has more procedural protections than the Berman procedure. And the way to get there, if in the Supreme Court, is to make sure that the procedural part of the unconscionability analysis is completely dealt with. I know they got to have a situation where you have big type, where the arbitration agreement is clear, and where there are no shenanigans going around. The person is explained. Somebody explains to the person that this, you're signing an arbitration agreement, you're waiving your right to go to court, and blah, and on and on and on. And then, if under those circumstances the courts turn around and say, well, we still think it's unconscionable, then that would be an issue I think that the court would be more interested in hearing.
Thanks
Certainly
for the wrap up. I appreciate it.
Time. All right. Thank you.
Well, there's always a guarantee of more arbitration cases coming down the road for the court, for sure. I appreciate you taking the time. Thank you both.
Thank you both.
Right, thanks.
Bye.